Communications contracts. Although this is a contract law course and not a communications regulation course, I thought it might be interesting to spend just a few minutes thinking about the obligations that arise under the communications regulatory framework and how they manifest themselves in terms of obligations around contract. There are two areas that I'm going to look at. The first is the issue of consumer protection and how the regulatory framework imposes certain obligations on consumer communications contracts. The second is at a supplier level and looks at obligations pertaining to regulated agreements. From a consumer protection perspective, there are three issues which are going to be of relevance: the right to a contract, obligations around minimum and maximum term, and the issue of dispute resolution. The starting point is that consumers have a right to a contract in a clear, comprehensive and easily accessible form which must contain certain information. The required information is set out at Article 20 to the Universal Service Directive 2002/22/EC as it's been amended, so take a look at that. But it includes the identity and address of the service provider, a description of the services being provided, and the duration of the contract and conditions for renewal, as well as quite a lot more. In terms of maximum and minimum term, take a look at Article 30, again of the Universal Service Directive. No communications service contract with a consumer can have an initial term of more than 24 months. This means that while a contract can continue indefinitely, the period for which a consumer is committed to the contract can be no longer than 2 years. After that 2-year period, the contract can continue to run if the parties are happy for it to do so, and the default position in most cases I've come across is that it does indeed just run on. But the consumer must have a right to terminate at that point if they so wish. The second requirement is that all providers must offer at least one contract which has a maximum duration of 12 months. In practice, most providers of cellular telephony offer prepaid SIMs which have no minimum duration and so clearly satisfy that requirement. Providers of fixed line services may need to make sure that they do comply with this obligation by offering at least one contract of 12 months or shorter. As I discuss in the Dispute Resolutions podcast, member states are obliged to establish simple and inexpensive out-of-court procedures for dealing with unresolved disputes between consumers and communications providers, and this includes disputes relating to contractual conditions and performance of contractual obligations. Of course, these requirements exist on top of other legal requirements. So, for example, a user who purchases an airtime agreement over the internet will probably have additional rights under the online and distance contracts rules. But these particular communication-specific rules are seen as an essential requirement for protecting consumers in a critical aspect of their daily lives: communications. Just for your interest, I have included in the materials a link to Vodafone's standard prepay and postpay contractual terms, just so you can take a look and see what they're like. The second issue that I want to talk about are the obligations that are imposed on, or can be imposed, in terms of supplier level agreements. The notion of regulated contracts. And these come about where a provider is in possession of significant market power, a position akin to that of dominance. Take a look at Article 14.2 of the Framework Directive 2002/21/EC. Where a provider has significant market power in a given market, a communications regulatory agency can impose a number of different obligations on that provider to attempt to prevent a distortion of competition. From a contractual perspective, this can include an obligation of transparency. Under such an obligation, a provider can be required to make certain information available for those who might want to interconnect with it, or to have access to its infrastructure. And this includes the possibility of imposing on a provider a duty to publish a reference offer for its services. Take a look at Article 9.2 of the Access Directive. A further obligation which can be imposed is that of requiring an operator to meet all reasonable requests for access to and use of specific network elements and associated facilities. In other words, an obligation to contract with a third party. Again, I have included a link in the notes, this time to the page on BT's website on which it publishes standardised reference offers, and you can take a look through and see the kind of things which it is required to sell. A separate specific obligation has arisen in the context of mobile phone roaming, predicated on the basis that an operator has de facto dominance in setting its mobile termination rate. The European Commission has seen fit to impose limits, including direct price regulation, on roaming services. Do take a look at the latest version of the roaming regulation, that's Regulation 531 of 2012. In particular, see Article 5.3, which requires mobile network operators to publish a reference offer and make it available to an undertaking requesting wholesale roaming access. There's also a requirement that an operator must provide a draft contract within 1 month of request, which is really quite quick.